All right, good evening once again. This is Attorney Alfonso Roma, your instructor in Criminal Law Book 1 of the Revised Penal Code. And tonight we will be discussing aggravating circumstances. Now, aggravating circumstances can be found under Article 14 of the Revised Penal Code. It simply provides circumstances which, if present in commission of crime, the penalty to be imposed when the actor or when the accused is found guilty will be at the maximum period of the law or of the penalty. So, we learned before, we have discussed before that the penalty has minimum, medium, and maximum periods. Now, the application of mitigating circumstances, aggravating circumstances, may determine the proper penalty to be imposed by law. And as you go deeper to the application of penalty, when the accused will be or may be found guilty, you will learn that there is a minimum period and there is a maximum period. The purpose of minimum and maximum is that when the accused serve the minimum period imposed by law, he is eligible for parole. Now, the maximum period is, of course, he will serve that up to maximum period, provided or provided that all other conditions are met. Say for example, if the accused will not apply for parole, even though reaching the minimum service of the sentence, he will continue serving up to the maximum. But then again, you apply what we have called that good conduct allowance. Good conduct allowance kanang naka sa detention, whether you are serving sentence or preventive prisoner ka, good conduct allowance are deductible number of days sa imong sentence kung magbinutan ka sa sulod mo na ang good conduct allowance. So, in reality, the maximum period of the penalty imposed by law, in reality, di na siya ma-reach kay na may mga deduction sa service of sentence. Now, we have talked about service of sentence. Ang kanang service of sentence, the accused is found guilty, then he is sentenced to this minimum period of penalty and then maximum period. Now, the penalty, the punishable, imposable penalty is affected when the crime is attended by mitigating or aggravating circumstances. In case of justifying circumstances, well, the act is justified, so there's no liability. In case of exempting circumstances, the law exempts the person. So the mitigating and aggravating circumstances and the alternative circumstances, as the next preceding paragraph, will determine the imposable penalty. So kung naay mitigating mo gamay ang penalty into minimum period, kung naay aggravating, ang penalty mo taas but within the prescribed penalty by law, which is to the maximum period. Kung walay mitigating, walay aggravating circumstances, the penalty will be at the medium period as provided for by law. So again, ang penalty na ay maximum, medium, and minimum. Then we apply if at during commission of the crime or during the committing the act, there is a mitigating or aggravating circumstance. So, aggravating circumstance mutaas kung present during commission of the crime. The Article 14 of the Revised Penal Code provides 20 aggravating circumstances. Now, you will later on learn that some of these aggravating circumstances are qualifying circumstances of murder, say for example, or inherent in a crime. Inherent ka nang naa siya daan. So you cannot appreciate that. In case the aggravating circumstances is present in crime, say for example homicide, the homicide will be qualified into murder. You will learn later on that murder or homicide has no special or qualifying circumstances, and mahimo ra na siya murder kung naay attending qualifying circumstances. So that's the distinction of homicide and murder. Ang homicide or ang murder na ay mga qualifying circumstances, na ay mga circumstances nga mo qualify siya ang act of killing to murder. So you will later on learn that some of these circumstances are qualifying circumstances of murder. You will later on learn that the these some of these aggravating circumstances are inherent in committing the crime. Inherent meaning kanang built-in na siya, naa na siya as part, or maybe inherent na siya because of the crime itself, or as part of the elements of the crime. Part of the elements of the crime. So, inherent. Now, ang aggravating circumstances are divided or classified into, I think it's 1, 2, 3, 4, 5. Aggravating circumstances may be classified as generic, which applies to all crimes as provided for by law. These are crimes that, as I've said, generic aggravating circumstances, applicable siya sa tanang krimen na naa sa bukto. We have specific aggravating circumstances, applicable lang sa isa ka krimen, because you cannot, say for example, treachery. You cannot apply treachery in case of theft. Treachery can be appreciated only in crimes against person, or in more common application in homicide or murder, as the case may be. So, first, generic, applicable, tanan. Second is specific, applicable lang sa specified crimes. And then, we have qualifying. As I've told you before, qualifying aggravating circumstances, mo qualify ang isa ka act if present na siya pag-commit sa isa ka crime. If present na siya, mo qualify, so mo elevate or mo taas ang krimen from the basic example is homicide, mo taas into murder. That's a basic qualifying circumstances as provided for by law. Now, I've said before, inherent qualifying circumstances, kanang naa na siya daan sa pagbuhat or as part of the elements of the crime. So you cannot appreciate it or apply it in addition to the crime because it is inherent, it's built in. It's part of the elements. And lastly is special qualifying circumstances. Special meaning the law provides that these are the special qualifying circumstances, and the law provides special qualifying circumstances on the definition of the crime itself, like robbery with homicide, robbery with rape. That's example of specific qualifying circumstances. Na siya daan sa krimen, appeal siya sa definition, and then if naapod ni na appeal pod sa pag-commit sa crime or present pod sa pag-commit sa crime, then ang balaod mismo naghatag og taas nga penalty. You don't need to apply aggravating circumstances separately and impose the maximum period of the penalty, because the law provides na nadaan di hatag na daan sa balaod kung naa ang aggravating. These are special aggravating circumstances. If the special aggravating circumstances is present, then the law also, ang balaod mismo nag-provide og special put nga penalty nga taas. So that's the classification of aggravating circumstances. The basic general classification of aggravating circumstances, and that is inherent or generic. First, generic. Second, specific. Specific was sa krimen. And then, third, qualifying. Fourth is inherent. And fifth is special. That's 5 classifications. So, remember that. We will move on to each paragraph of the aggravating circumstances on the next video, because it will not cover under, or it will not fit under 15-minute period. See you again.